He is also an executive committee member of the MCIA's Maritime User Council. He is an alumnus of the Korean Academy of the Law of Seas. Next, we have Professor Dr. Bimal Patel, who is the Vice-Chancellor of the Rashtriya Raksha University. He is the lead academic advisor of India's membership to the UN Security Council for 2021-2022. He has been elected as the UN's International Law Commission for a 5-year term, commencing from 1st January 2023. As an international law jurist, he has extensively published works on administrative, procedural, and substantive jurisprudence of the International Court of Justice, International Tribunal for the Law of the Seas, International Criminal Tribunal for former Yugoslavia, and International Labour Organization. Lastly, we have Mr. Rahul Narichania, who is a senior advocate designated by the Bombay High Court. He is regarded as the foremost senior counsel for India's shipping and maritime disputes. He is recognized as Band 1 Senior Counsel by the Chambers and Partners for India Shipping category. Over to you, Mr. Singh.
Thank you, Pushkar. Hello everyone, and very good afternoon and welcome aboard. Before I begin, I would like to not miss an opportunity basically to acknowledge the good efforts of MCIA always being the torchbearer in taking the international arbitration in India forward. In fact, this has been a very significant step towards promoting the capacity building in arbitration by creating these user council. This is internationally with the organizations like ICC, MCIA and all, we have seen those are more, user council are regional specific. But with MCIA, these are more sector specific user councils, and the whole idea was to basically promote and bring all the stakeholders together in basically exchanging ideas and authoring basically white papers about it, doing events and generally bringing them together, creating a pool of arbitrators and the knowledge bearers who can basically take on the mantle for resolving the disputes in those particular sectors. So I am actually honored to be here as a representative of the Maritime Users Council of MCIA, and we have deliberately chosen this theme of a fireside chat because we are warming up to the maritime arbitration, and this is the first session of a user council being held, and there could not be a better place to hold a maritime arbitration event than Gujarat, which is actually the hub of maritime activities in India, and also to be held during one of the annual flagship events of MCIA. In fact, I'm very glad to be here. There are no housekeeping announcements as far as the fireside chat goes. There is only one announcement I would like to make, that we have kept time for the Q&A at the end, unless somebody has a pressing question which must be dealt with immediately. So you can raise your hand and we'll come back to you. So let me begin with what India is basically doing. See, we must understand that there is an ever-increasing demand for the food and energy security around the world, and so is with India. And that is why there has been an impetus and an undying focus with the government to basically ensure that we make all our resources seawards, we basically utilize them in the best way, and we make provisions in the laws that govern the exploitation in our neighborhoods. So with that, we came up, the government of India has come up with something called as the Maritime India Vision 2030. And also, if we see, there is a report by FICCI of basically the capacity building efforts in the maritime sector for 2025. And now, specifically talking about the Maritime India Vision that respect to the dispute resolution. There is an initiative 4.5 and the initiative 8.12 for the people who have read the report. If you haven't read, just for your convenience, 4.5 and 8.12. 4.5 talks about the two issues: introduce ability for dispute resolution through conciliation as part of institutional framework. Now, there is a question that will arise from there whether the government should be creating institutions of their own or let the private parties do it. And second one is establish clear monetary limits for the appeals to improve the arbitration process. And that whole effort is basically revolving around the doctrine of the resolve in India. Like Make in India, there is a doctrine for resolutions to take place, the dispute resolution to take place in India itself. And there are four important subjects to that, which this Maritime Vision has basically spoken about. And very importantly, it talks about something like the London Maritime Arbitrators Association is there. We have wanting to create something called as Indian Maritime Arbitration Association. So there is a distinct difference. That's a private organization and association of private practitioners. What we are trying to do is a government organization for the arbitration association. So I don't know what the difference is going to be. So my question basically, Dr. Patel, is that we have seen that there have been a lot of amendments that have been brought out and a lot of archaic maritime and the shipping laws that have been done away with. And we have the amendments in the Admiralty Act of 2017, the amendment of the MCIA also, Merchant Shipping Act also. And then what kind of the recent trends have emerged? That what kind of disputes do you see is being is coming for the adjudication, and what are the new the Pandora's box that has opened after this the new acts and the amendments and the legislations that have come about in India?
Thank you very much, and I thank MCIA for inviting me to this very important seminar, commercial arbitration, the way forward, and subset of it is maritime arbitration. To begin with, I would say maritime and sports, these are going to be the two biggest drivers of Indian economy, and corresponding creations of disputes in these fields are going to be equally important. And therefore, though maritime and sports verticals in the country have started taking shape now, we are yet not too late. Of course, we have lost a huge amount of time for the previous sector, but now in these two sectors we really have, we are really at the cusp of the transformation, and we should be really focusing on both sectors. Within maritime sectors, I would only identify that maritime arbitration is, maritime field is huge, but there are three important sectors. Why? The external field, which is very important for India, the special economic zone, and the third is basically the National Maritime Development Program. In my view, our current capacities and capabilities enable us to suggest that these are the three areas in which we really have to put up our efforts. I am not discarding that other areas of maritime economy are not important, but I believe these three areas in which the government of India is giving huge significance. Therefore, we should definitely focus on this. You mentioned about the Sagar program also briefly. So I'm talking National Maritime Development Program, and when we are talking of GIFT City as well, GIFT City is what? It is of course the special economic zone what we are talking, but also it is a huge amount of maritime importance. Within GIFT City itself, we are also looking at ship leasing, and there is going to be, both aviation as well as ship sectors are going to occupy a lot of attention as far as the international financial city in Gujarat is concerned. So, first of all, we have to identify these three areas, and within these three areas, we can go for identify the issues and the stakeholders, and then we can draft out the rules so that to begin with, these three areas of the government's interest are catered to. You asked about question, what are the important issues which are currently being addressed as far as maritime arbitration is concerned. We have to look at not just, of course, all of us are kind of fans to LCIA in Hong Kong and Dubai as well, but I think we should also look at in a huge way to Nordic arbitration. I think the focus on Nordic arbitration has been missing so far in our literature. Keep in mind that Nordic arbitration or the Nordic countries are the major seafaring nation for centuries. And these Nordic countries are known for their efficiency and effectiveness. Whereas, of course, we believe that we all are acting to the LCIA particularly, and being a common law country, you would like to go for the stability and predictability of outcome to LCIA. But I do believe when we are talking of the Admiralty Act 2017 as well, we should really look into this Nordic arbitration. Similarly, again, the safeguards and reliability of independent and impartiality of arbitrators, which is again becoming one of the huge issues. And here my suggestion would be, more than legal expertise, we should go for the commercial domain. I think this is something which is very, of course, a judiciary would definitely insist upon persons only with legal acumen. But if you look at, I'm talking the Nordic arbitration, I'm talking the European maritime arbitration as well, they have significantly relied upon the commercial people who are involved in maritime matters. So this is an area where I think we could definitely work upon. Another is arbitration clause, particularly in the incorporated charter party. In this breakup session, I was also talking to my colleague here. Do we have, can we incorporate and make it mandatory whenever we are drafting the contracts? So I think these are some of these issues to begin with our discussion need to be addressed. I think that itself will do a great service to the maritime arbitration future in India.
Thank you, Dr. Patel. You basically mentioned about the draft national maritime policy and the Sagar doctrine and also blue economy perspective. Basically, what I was trying to understand is that for the sake of the audience also, that we have had these amendments, and Mr. Rahul, I'm basically asking you, that with these amendments that have happened to the Act, like let's say for example the ship arrest or basically the right to obtain securities, basically before pending arbitration. So what kind of issues are emerging now? What kind of disputes are basically coming up with these new amendments to the Admiralty Act and basically the legislations that have been in India for a very long time?
We have the 2017 Act, which has just recently come into force. But before that, our law was clearly antiquated. We were following the English 1840 Colonial Codes of Admiralty Act 1840 and the 1861 Act. And both these acts were made applicable to India by the Colonial Codes of Admiralty Act 1891. Now, it's only for the first time in 1993 that the Supreme Court of India found that India was lagging behind as far as legislation was concerned, and that other major seafaring nations in the world had marched ahead in time. So for the first time, the Supreme Court laid down the law to expand the jurisdiction of the court by going so far as to say that the English Brussels Convention on Arrest of Ships 1952, though not forming a part of Indian law, would be considered to be a part of our common law. That led to courts in Bombay taking the view that arrest of sister ships are now possible by virtue of the 1952 convention applying to India. This then led to the Geneva Convention of 1999 also being made applicable to India by virtue of the judgment of the Bombay High Court in the MVC success case, which was affirmed by the Supreme Court again in about 2003. Now, maritime law has got strong international overtones. Majority of Indian trade is carried on foreign ships, and it is important for India to ensure that there are adequate legislations in place to protect the interests of Indian companies, Indian traders, Indian shipping companies vis-a-vis foreign companies, because the laws in those countries are so advanced that they give wide-ranging powers to the courts to take action in rem against Indian ships, and it is therefore necessary for India to also have a similar framework. Now, in 2017, we've had the Admiralty Codes Act, and pursuant to that, we have almost come to par with other nations, save and except for Section 5 of the Act, which is not very happily worded because it has taken away certain rights which were in fact given to India under the Geneva Convention 1999, which was made applicable by the Supreme Court. Now, the 2017 Act, for the first time, took away the pan-Indian jurisdiction of the Bombay High Court, the Calcutta High Court, and the Madras High Court. Under the Colonial Courts Act of 1891, these three courts had pan-Indian jurisdiction. In point of time, Bombay took a consistent view that it had pan-Indian jurisdiction, but Calcutta and Madras differed. Now, 2017 Act has granted jurisdiction to all the coastal states in the country, as a result of which these three chartered courts have lost their pan-Indian jurisdiction. Of course, if the vessel is in Maharashtra, you can arrest the vessel in Maharashtra through the Bombay High Court, and the vessels in Tamil Nadu, you can arrest it through the Madras High Court, so on and so forth. But the pan-Indian jurisdiction has been taken away, and as a result of which considerable amount of litigation has now come to the Gujarat High Court. Gujarat has got about 40 ports, about one major port which is the Kandla Port Trust, which is now named the Deen Dayal Port, and 40 other ports roughly, some of them are privately controlled. Now, so you can imagine the number of ships that are coming to Gujarat. The litigation in Gujarat is going to increase manifold. In fact, it has increased manifold. And therefore, it is necessary now to have a proper framework for regulating disputes through the aegis of arbitration.
So that's a very good account of what are the changes that have been brought in as a result of the new amendments in the Admiralty Act. Of course, that's a good point. We'll take it forward. The ship arrest provisions and the security provisions that can be done still. So we will see if we can make provisions, and we'll make recommendations to the government to bring about some kind of amendments to improve and give jurisdiction for Indian courts. Of course, the 8 coastal states of India have now been extended as maritime jurisdiction. In fact, so much so that we talk about the maritime as a specialized branch of arbitration. We must understand where it all began. It all began with Lex Mercatoria, actually. That's the mother of all laws, and that's the law of the merchants. And that's where the maritime arbitration has existed for a very, very long time. In fact, when we were talking about the capacity building, with those so many kind of provisions that the government has made, now the focus is being the food and energy security, and especially the maritime. In fact, one of our speakers, Ms. Avantika, she is the CEO and CEO of the Maritime Gujarat Board and the CMD of the Gujarat Maritime Cluster. Unfortunately, she is sick and she could not join us. But that actually brings me to the Maritime Cluster. India did not have an evolved Maritime Cluster for a very long time. In fact, the recent transshipment hubs have come about in the Andaman and Nicobar Islands. And transshipment hubs like in Hambantota in Sri Lanka and Singapore and Mauritius, they have been fairly well developed much before in time. So despite being a maritime nation, despite having such a broad coastline, and the whole theme of this particular event is ports for prosperity. The prosperity basically emerges from the trades that will happen through the ports. And trade is essential to any law. If there is no trade, there is no law required. If there is no law required, I mean, there is no legislation around it to regulate anything. And the more the trade, the more is the law, legal legislation which are required basically to control engagement of people in that. So when we are talking about the capacity building, it's about building the maritime trade in India. And with so much efforts, India, the government has actually infused 125,000 crores of money in development of ports, the hinterlands and the inland waterways. There's a lot of disputes that are emerging out of that. How are we handling these disputes? So basically, my question to Dr. Patel now is that that we have done so many efforts and brought about so many new provisions and infusing so much of money. What do you think is lacking, or do you think there is a gap which needs to be filled as regards to capacity building in India as far as the maritime trade goes? How can we improve and attract the international trade to India? How can we make India as a maritime hub for the maritime trade? How can we bring in the P&I clubs here? How can we bring in the international law firms to set up shop in the GIFT IFSC? Is it happening? Is it not happening? Is it not happening? Why is it not happening? And what do you think can we tell the international participants? I mean, of course, they'll be hearing from us that what is that India doing for them? To bring them here, to give them a suitable environment. Of course, dispute resolution is a very big bit of it.
Since we are focusing on dispute arbitration, let me also put this entire maritime arbitration in proper perspective. For this lecture, I was working on some statistics and quite surprised. So I will just put it out here. The latest maritime arbitration number in London, approximately 1700 every year by the London Maritime Arbitration Association. 1700. In the same period, 1715 maritime arbitration were held in London. So I'm not talking LMMA, I'm talking the MCIA and LCC. So on 1750, so 1700 plus 1750. The London strongest competitor, of course, we know is Singapore, and of course they have started establishing club across the world as well. Now, if you look at Singapore saw less than 10% of London's maritime arbitration case law. So you can see the difference between London as well as Singapore. And then you look at India. So again, if you would look into this Lloyd's arbitration reports, those which are reported actually, just we are talking less than 90. So there is no match. So in other way, what we have to do, in my personal view we also have to ask either we can say one of the 4 important consulting companies, the profitability of arbitration in India. So far, when you see the report which is coming out of the government of India or from the MCIA to an extent, for example, World Bank other day were mentioning because of the lack of dispute resolution situations, India is losing out so much percentage of GDP. I'm not looking into it. I'm looking at profitability of arbitration in maritime arbitration. If Government of India, for that matter, MCIA or even organizations like my university would like to carry out such a study, that would actually give ideas to the maritime community why we should be coming to India. So we have to bring a lot of commercial approach to maritime arbitration, but there is more of a strategy. This another aspect is, of course, we all are knowing about the lack of well-trained and experienced maritime counsel arbitrators. How do you prepare? We are talking of capacities and capability buildings. One area would be, on a very regular basis, we should be having a dialogue between the academia, with bar as well as judiciary, and also the government of India. So it should not be like once in a full moon day we are organizing such kind of conferences. It is a sustainable movement. So if you are going to organize seminars discussing on each aspect of the maritime arbitration, I'm sure a lot of awareness will be created. Today itself that we have organized this seminar itself shows that there is an appetite for people to understand and also to learn about more about awareness. Second is about India has signed 32 maritime conventions under the IMO. 32. So in Asia, India is perhaps after Singapore is the largest country which has signed so many. Unfortunately, all these disputes which arise under the 32 maritime conventions are being, as I said, either disputed, resolved out in London or in other jurisdictions. Is it possible? Government of India can insert a clause that any dispute which arises out of the interpretation and implementation of those 32 conventions of which India is a party shall be, as a matter of preference, be resolved only in India. It doesn't require rocket science. I can tell you the government of India is very prompt, and the government would simply say, fine, let's put the clause. The way we are incorporating, in any contract clauses, can government come up with a fiat rule? It is perfectly possible. Similarly, again the emphasis on technical expertise versus legal acumen. We are all talking of maritime arbitrators, maritime counsel. So while we are talking a long way, but if you look at London as well, they have been giving a lot of emphasis on the commercial or technical expertise versus legal acumen. So these are the areas where we have to focus on the capacity. And let's be also realistic, we will not be able to change the maritime arbitration landscape overnight. It may require maybe at least 10 years of sustainable discussions, and we are talking 20, 30, 35, when we would have sizable number of cases on maritime arbitration, maritime disputes will be coming to India or for example in Gujarat.
Very well said. In fact, that makes me say that London still is a cynosure of maritime arbitration. If you come, before I come to that, in fact, institutional arbitration as compared to other jurisdictions internationally, I would like to ask Rahul, that what is India doing? What are we doing and what would we like to do and propose? Why still, it's been like, if you consider that report of development of this maritime cluster in Gujarat, it's in 4 stages. We are at stage 3. We were supposed to have had the P&I clubs, international P&I clubs, the ship owners, the ship, freight forwarders, and everybody to come set shop in the gift city by now. Why is it not happening? What do you think is lacking Is it again the legal, jurisdictional interventions or the attitude of the courts? It is about the settlement of disputes and no mechanisms or suitable dispute resolution mechanisms. What is it that's preventing people to look forward to setting shop in India?
So I'll answer this question in the perspective of a dispute resolution mechanism. England is streets ahead of us. Let's be very clear about it. Let's be realistic. They have the finest arbitrators in the world, and I mean better than any other country, better than the United States, Singapore, anywhere. They have the finest naval architects who can decide technical disputes, chief engineers that can decide disputes relating to the working of a ship, master mariners who can decide issues relating to the navigation of a ship in the context of collision claims, salvage, etc. They also have QCs, that's Queen Counsels, who are very competent in Admiralty and Maritime law, having appeared in several cases in arbitration as well as in the English courts. So their arbitrator panel is extremely specialized. Now, in order for us to get there, merely having a strong infrastructure, very nice arbitration rooms, technology, secretarial assistance is not good enough. You need to have an excellent panel of arbitrators. And for that, you need to be very discerning when you select your arbitrators. You just cannot select an arbitrator because he has a shipping background. You need to be very sure that he is specialized in the field. He can draft awards. His drafting skills are very important. So if you do not have a good panel of arbitrators, ship owners abroad, charterers abroad are going to be very apprehensive of agreeing to an arbitration clause which confers jurisdiction to an arbitral tribunal here in India. That's the first thing. They are also very apprehensive because in case they succeed in an arbitration, they know that there's going to be a huge bottleneck in courts. First of all, if they succeed in arbitration, the losing party, very often it's a public sector company, will file a Section 34 petition in the High Court. Now, my experience as a lawyer practicing in Bombay is that it takes sometimes as many as 2 to 3 years for a Section 34 petition to be heard. Now, if the court finds at the admission stage that there is something to be said, the court will admit that petition, and it may take another 2 to 3 years for it to be actually heard and decided. Thereafter, there is a statutory right of appeal under Section 37. Again, if the appeal court feels there's something in your case and if it admits it, it may take another 3 to 4 years. If you again succeed in the appeal, there's a possibility that the losing party will file a special leave petition in the Supreme Court, and again you'll be stuck for another year or two in case the special leave petition is admitted. So we're looking at about 8 to 10 years. Now, the Arbitration Act in India, with the avowed objective of concluding arbitrations as expeditiously as possible, has imposed a 1-year time limit for conclusion of the arbitration from the date the pleadings are complete, with a 6-month period of extension. But with the best will in the world, even if you succeed in the arbitration within a year, year and a half, you're going to be stuck in court for almost 8 to 10 years. Now that can be very, very frustrating for a party who has succeeded in arbitration, and that is why foreign entities are very apprehensive of including an arbitration clause which confers jurisdiction on an arbitral tribunal here in India. Now, there is the Indian Council of Arbitration in New Delhi, which has its own maritime arbitration rules, and public sector companies, especially oil companies like BPCL, IOC, HPCL, they always insist that there is an arbitration clause which institutionalizes arbitrations through the aegis of the Indian Council of Arbitration. Now, ship owners here agree to the inclusion of such a clause because they're getting regular business from these public sector companies. Their ships are being chartered on a regular basis, sometimes 10 to 20 voyages in a year. So they're earning a lot of money in terms of charter hire or freight as the case may be, and they do not want to lose that business. So they reluctantly agree to the inclusion of such clauses. But in a situation where the ship owner is not under any commercial pressure, he is not likely to agree to this unless there is a overhaul in our judicial system. You just cannot have a section in the Arbitration Act which imposes a time limit of 1.5 years, but then does not in any manner legislate as far as the duration for disposal of a section 34 or 37 or for that matter special leave petition. So that's the biggest pain as far as arbitration in India is concerned.
Sure. Dr. Patel.
Can I just add what Rahul is saying? Again, just statistics to substantiate your case. If you look at Singapore, the average duration of any maritime dispute is only just 11.6 months. So versus we are talking 8 to 9 years. If you look at London, maximum is 16 months. If you look at Hong Kong, 14 months. So obviously, why those people should come to India? So I think, is it possible to reduce, let's say, from 8 or 10 years to 11 months, 13 months? So these are the kind of statistics. Similarly, now here the duration versus cost factor. Now, if you look at again the same jurisdiction, Singapore costs, if it is a sole arbitrator, anywhere about $27,000. Now, if you look at the ICA rules, and I was just going through, it is 10 times cheaper to maritime arbitration. But if you look at the time duration is unacceptable. So there is a big gap between the cost factor and the time duration which taken. I think we are losing out in a big way in this. Number two, the Indian Council of Arbitration has clearly mentioned, they have the maritime arbitration rules. In the maritime arbitration rules, they have clearly mentioned that every maritime contract shall incorporate a clause, which is also given in the maritime arbitration rules of. However, I'm talking in 2004, but even in 2022, how many maritime contracts which are concluded by our Indian seaports are including that particular clause? In other words, there is a requirement also to create better awareness on part of this Indian seaports.
That's what Dr. Patel, that's what I'm trying to dig into, is to basically identify. If you see, many people do not get this right. The London Maritime Arbitrators Association, LMAA, does not administer arbitrations. Any arbitration done under LMAA is an ad hoc arbitration. So it's not an institutional arbitration. But yes, it provides provisions, it has measures, rules very specific to the value of claim. And many a times, parties initiate arbitration basically to stop the clock of limitation ticking. And then they go into negotiations and settlements, they bring in settlement awards. And sometimes before they go into the arbitration, there are certain measures that the parties must take, interim measures, basically to protect their claims. So, while talking about the London arbitration, of course, see, when we compare London with all other jurisdictions, whether it is Paris, Singapore, Hong Kong, Dubai, New York, and Mumbai, all combined together with compared to London, if you do a bubble chart, they will actually look like a penny farthing. I mean, they do not even compare. So, what is the reason? See, we still got to see what happens after post-Brexit. Pre-Brexit, London saw the maximum maritime arbitrations, yes, but we're still not sure what happens post-Brexit. But the moot problem is, even if we come up with the best institutional rules for maritime arbitration in India, how do they find their way into the dispute resolution clauses in the contract? So that's what I want to ask you, Rahul. Even if we get the best of the rules, let's say, which is comparable to the best standards in the world, how do you think are they going to find it? Let's say you know somebody, a client, you can tell them if they're doing a maritime contract, insert this particular clause of ICA, or let's say MCIA has a maritime clause. Is it required that institutions should have dedicated sector-wise rules? Can they be combined rules? Can't we do maritime arbitrations under the rules which are existing right now? Or even if, let's say, we come up with specialized rules for various specific claims of maritime, how will they get into these contracts? We have the rules, but we are still not finding the place in these contracts which have been done for the maritime. So, how do you think this is going to be achieved?
The only way you can encourage arbitration in maritime law here in India is, first of all, if you have, as I said earlier, and I'm repeating it, I hope I'm not repeating it ad nauseum, you have a really good panel of arbitrators. And infrastructure, of course, is very easy to have. MCIA has got a great infrastructure, but you need to have a good panel of arbitrators. You could even possibly encourage arbitrators from England and other countries to empanel themselves so that you can have diversity and you can be in a situation where you tell the world that we've got a panel of arbitrators who are very competent, they are specialists, and they are unbiased and impartial. So if you have a good panel of arbitrators, everything falls in place. So that's the first thing you need to look at. Everything else will fall in place.
Well said. I think let your ambassadors speak for you. I mean, institutions which have their panels, let the arbitrators speak for themselves. I think that's what the MCIA is all about. I think
I'll just add something else if you don't mind.
Sure.
Yeah. Now the kinds of maritime disputes that are agitated in arbitrations are, for example, cargo claims, damage to cargo, shortage in cargo, contamination of oil cargo. Then you have claims for demurrage, dispatch. For those of you who don't know what is demurrage, it is a claim for liquidated damages due to delay in loading or discharge of a ship by a charterer. So in every charter party, or that's a contract, you have a certain number of days which are permitted to a charterer for loading and discharging operations. Those are called free days or lay days. If the charterer exceeds those days, exceeds those number of days, then the vessel goes on demurrage. And the amount of demurrage payable is specified in the charter party itself. So for example, if you take 7 days in excess of the time given to you under the charter party, and the demurrage clause in the charter party mentions that you have to pay $10,000 per day, you'll end up paying $70,000 as demurrage to the ship owner. Then there are other claims such as freight, non-payment of hire, indemnity claims, claims where a ship has made contact with, say, a virtual jetty belonging to an oil company or to a special buoy mooring or to port property. And you have claims relating to accounts between a ship owner and charterer after the charter party has been concluded. Now, this is a very specialized jurisdiction. It definitely needs specialists to handle such kinds of cases. Now, I was dealing with one case where the matter went to arbitration in relation to a claim for freight. And the arbitral tribunal here, consisting of 3 commercial arbitrators, all they did was record the submissions of the claimant, the response of the respondent, the rejoinder of the claimant, and proceed to hold that according to us, the claimant is entitled to X amount of rupees in relation to claim 1. As far as claim 2 is concerned, we reject it. This is how they drafted the award, which effectively is an unreasoned award. Now, you may quote all the submissions extensively, but if you do not give your reasoning, the award is bad in law. Now, that very award has been challenged in a section 34, and the successful party has filed an application under section 34 subsection 4 for remand of the matter to the arbitral tribunal to cure the defect in the award because there are no reasons given. But that petition itself and the application under 34.4 has been pending for 4 years. So you can imagine the plight of a successful litigant.
Yeah, that's right. That's right. In fact, somebody mentioned to me while in one of the conferences that it's our own lawyers and stakeholders which do not want the ADR to progress. I said, how is it possible? They said that ADR does not stand for alternate dispute resolution. It stands for aggravated decline in revenues for them. So even that, in fact, recently we have undertaken a survey. I am an advisor to the Indian Ocean Region Association with IORA, and we have done a very elaborate survey, and we have found the 3 biggest issues that the ADR is facing in this jurisdiction. The first one being, of course, the lack of specialized rules to meet the demand of the clients. Second one is the difficulty in enforcing the interim measures and emergency awards. And third is the unfavorable attitude of the judicial authorities. I mean, we all know that law is a living organism. It keeps changing. But nobody would have really wanted it to become a chimera with a new head popping out every few years. Things change. So the thing is that that brings me, we have paucity of time. I would like to ask Dr. Patel also to begin with. Do you agree that the arbitration or the ADR should be completely a private affair and to be done with only business, like a business, to be run like a business? Should government have any role to play? And recent practice, government bringing up their own institutions, government funded, government run, government appointed, references from the courts happening to those particular institutions. Should that be allowed, not allowed? Is that a good practice? Will that attract international investment or not? Does it affect the FDI or not? Ministry says it does not affect the FDI. But is this practice between the government let's not say interfering, engaging in the activities of arbitration and then further output results into the appointments like that. So what do you think? The question is whether it should be completely privatized, run like a business, or should the government still hold stake in running these kind of institutions?
Obviously, you cannot take government out. It is the biggest stakeholders in maritime disputes. Nevertheless, what we could do is, for example, each of the coastal states under the Admiralty Act, now they have special court on Admiralty jurisdiction. Now, government can proactively play an important role as a facilitator for asking each of the coastal states of India whether they have established special court or not. Secondly, even the Gujarat High Court, and as Rahul was also mentioned earlier, Gujarat has perhaps the largest coastline within India and huge market, 44 minor courts for major courts. Even today, after 5 years, the Gujarat High Court has not framed the rules. I mean, you do not have to reinvent the wheel. You can completely copy paste, to an extent from London or Hong Kong or Singapore. You try to adapt because it is time tested. Why people are going to London, Hong Kong or Singapore? Because those rules, they have been defined for now decades, and there is certainty, there is a predictability. The Gujarat High Court as well as Gujarat government should have simply adopted and said, okay, let's start working on it. Now, so much of lethargy. So, I would personally believe that, of course, therefore, there is a case made out for complete private arbitration, but at the same time, the government cannot and will not get out of the business, because I think, it is one very important thing is, and I don't know to what extent Rahul will agree with me, but majority of the cases in London and Singapore, as far as maritime arbitration are concerned, they are disposed of the documents. And here, very, very limited cases, they are going for the physical sealing. Unfortunately, I think in India, again, I'm subject to correction, but we still insist a lot on physical sealings, and that in fact adds into the longer duration of the arbitration matters. So these are small, minute things which we can simply incorporate to change. One more important thing is all this basically this bill of lading. So modern arbitration forms with grain, with gas, with oil, you just name it. What we have to simply do is those model rules and model forms are already prepared. We simply have to adapt in our maritime contracts. Now, if that happens, and I think that can be done by council themselves as well, those who are advising the parties. So I think these are small things, low-hanging fruit, I can say, but these low-hanging fruits can really give a big boost to the maritime arbitration in India.
Actually, in fact, let me also bring it to your notice that LMA is a private organization. It's an association of private practicing arbitrators. Also, the SCMA, the second best maritime institution, is also funded and done by the Singapore Maritime Association. It's an NGO. It's a non-profit organization. I really cannot recollect if any of these best so-called institutions is being run by the government fund. So, Rahul, do you agree with that? I mean, do you think that dispute resolution, ADR, should be a completely private affair and run like a business, or should the government will have or should have their stake in running that particular thing?
It's difficult to exclude the government entirely. The government has taken the initiative as far as the MCIA is concerned. So, but the more participation by the private sector is always welcome, because it brings in a lot more professionalism. I don't mean to be derogatory in what I'm saying, but when you're dealing with the government, there's always some element of bureaucracy, red tapeism, lack of promptness or efficiency, and that can be taken care of if you have the private sector handling all these issues, with the government taking a back seat, but participating from the
I'll just make it more interesting. I'll make it more interesting for you. I'll reframe the question. Do you think, okay, let's forget about the institutions being run by the government. Do you think the ACI, of course, what the intention of the ACI was, basically, should the government regulate appointment of arbitrators?
No, I don't think so.
Okay, well said. Thank you. So I think we are closer to the time. Also, there's one last thing I would like to ask Rahul. is that before you get into arbitration, of course, the parties would need some kind of a security for your claims. And how do you basically protect your claims before you go into arbitration? What kind of measures will you seek?
Right. So I'll answer this question in the context of maritime law first. Now, as you're aware, under the Admiralty Codes Act, there are various maritime claims for which you can take action in rem or in personam against the ship and or the owner of the ship or the Vice-Chancellor of the ship. You also have a right to institute arbitration proceedings for recovery of your claim, which invariably is a maritime claim. Now, if there is an arbitration clause, it doesn't necessarily mean that you have to necessarily only take the path of Section 9 of the Arbitration Act, which has now become applicable even to international commercial arbitrations as well as commercial arbitrations under Part 2 of the Act. But you can, in fact, file a suit against the ship, and in law, a ship is treated as a juristic personality. So you can sue the ship as a defendant. Defendant number 1, you may sue the ship owner as defendant number 2, and pursuant to an action in rem, you may proceed to file an admiralty suit to arrest the ship, but you must seek a judgment and a decree against the ship and or the ship owner as the case may be. Now, it is then that the ship owner will come forward to release his ship. When he comes forward to release his ship, he will invariably inform the court that there is an arbitration clause. In breach of that arbitration clause, this particular claimant or plaintiff has proceeded to file a suit. The matter should be referred to arbitration either under Section 8 of the Arbitration Act, where Part 1 is applicable, or under Section 45, where Part 2 of the Act is applicable, which is a foreign arbitration. In that event, the court may, in its discretion, direct the security to be retained in court. So the court will direct the ship owner to furnish security to the extent of the claimant's claim, and then direct the parties to go to arbitration. Now, this issue came from decision before the Bombay High Court. Justice Sriram, in a case called CMSIEM versus Altus Uber, took this view, and he said that if you file a suit seeking a judgment and decree, then the court will grant you an order of arrest if the case is made out, and if the ship owner comes forward later on to release the ship, he will be directed to furnish security for the claim, and the court may then choose to refer the matter to arbitration. This was affirmed by another judgment. The same judgment was taken in appeal, and it was affirmed by the division bench of the Bombay High Court, and now a special leave petition has been filed and is pending in the Supreme Court. But as the law stands today, despite the existence of an arbitration clause, you can file an admiralty suit, but you must seek a judgment against the ship in rem, and then everything will fall in place as I just mentioned before. Apart from that, you also have a right to file proceedings under Section 9 of the Arbitration Act for interim relief. Now, the most important thing here is, many people believe that when you file an action under Section 9, the powers of the court are circumscribed by Order 38 Rule 5. Now, those of you who are not practitioners, may I inform that Order 38 Rule 5 of the Code of Civil Procedure is a provision which grants the court powers to order attachment before judgment in favor of the plaintiff and against the defendant, where, in a limited case where the defendant is making attempts to defeat and or delay any decree that may be passed. For example, if he is trying to sell or alienate his property with a view to defeat or delay your claim, in that event, the court may grant an order of attachment before judgment. So the view that was earlier taken was that the court cannot grant you an order under Section 9 unless you satisfy the test of Order 38 Rule 5. Now, recently the Bombay High Court in Jagdish Ahuja's case, which was then followed by the Valentine Maritime case of the division bench of the Bombay High Court, held that the powers of the court under Section 9 are not circumscribed or in any manner, nor is the court bound by the provisions of Order 38 Rule 5, and if it finds that justice demands that security is required to be furnished or an injunction is required to be granted because the plaintiff's claim is prima facie maintainable and the claim is payable, then in that event the court will grant a protective order pending the arbitration. So that's a very good remedy and a weapon available in favor of the claimant to protect his interest whilst the matter is being referred to arbitration.
Well, that's a very good free advice you've given everybody. They can protect their claims. So now we have neared the time now, and unless somebody has a question, does anyone have any questions to the panelists? Okay, so before I close, I just wanted to give you two statistics after this survey that has happened. I don't know, I would like to understand from anyone, whether they agree or not, that the most preferred seat for arbitration in the Asia Pacific and the IORA has emerged as London, Singapore, Paris, Hong Kong and Mumbai. In fact, it's a very, I'm glad to note that Mumbai has also become one of the preferred seats of arbitration, at least in the Asia Pacific and the IORA region. And the two most important considerations that have come for selection of an arbitral institution is, one is, of course, like Rahul also said, the quality of arbitrators, and they want to see the competence of the secretariat of the institution. That's also pretty interesting to note. And as far as the seat for arbitration goes for the maritime claims in the IORA region, I think the top two has been India and Singapore. So I think that's a very good improvement. Let me also tell you who the stakeholders of the survey were. These were, we got a result of 211 active lawyers, arbitrators, legal professionals and officers in the ministries from all the regions, all the 23 countries in Singapore and Asia Pacific and all around the world actually. So that's a good improvement. In fact, before I end, I would also like to acknowledge the good efforts of MCIA and being the torchbearer of international arbitration, truly international in the sense. And also for the capacity building, coming up with this Users Council, and on behalf of the Maritime Users Council, I really extend a big thank you for MCIA to having allowed us to have this maiden event right in the middle of Gujarat and on their annual flagship event. So we are very glad. Thank you so much. And of course, this is nothing without all of you. Thank you for being here. Thank you for staying back. And of course, thank you for being participative and kind to the panel. And we look forward to seeing you sooner than later. Thank you. Thank you, everyone.